Hello and welcome to another Legal Fireside. Today I'm joined by Marlia Saunders, who's a partner at Thomson Geer. Marlia, welcome.
Thanks, Jerome.
Now, today we're going to be talking about the stage two defamation law reform proposals. What they are, why they're being proposed, and what does this mean for lawyers in the defamation space. Obviously, defamation is a hot topic, not just in legal media circles, but also in mainstream media. There's been a number of high-profile cases in recent times. No doubt there'll be more coming down the pipeline. And so it's a good opportunity for us to talk about the proposals that are currently in the making, and what they all mean. So Marlia, tell us about these stage two proposals, and I guess why they're coming about.
Sure. So these proposals were released around a couple of weeks ago by the government. And what they focus on is internet intermediary liability for defamation. And they've come about following a series of cases over the last kind of 10 years or so. First of all, against Google in relation to their operation of their search engine. So there's been a number of cases such as Truculia and Duffy in the Victorian state courts and then in the South Australian state courts, which held that Google was liable as a publisher for snippets in its search results for any defamatory material that's conveyed via those snippets in their search results once they're put on notice. That content may be defamatory. So that line of case has really diverged from case law overseas, particularly in the UK, where it was held that Google is not a publisher of snippets because it doesn't authorize or cause the snippets to appear on a user's screen in a meaningful sense. It's only a facilitator. So the law in Australia really went in a different direction. So that's one issue. And then the other big case was the Voller case that went up to the High Court about a year ago now. And in that case, the High Court held that various mainstream media companies were liable as publishers in defamation for third-party comments that were posted on their Facebook pages. So that was where the media companies would post links to articles on their website or to store videos that were on their website, which themselves were not defamatory, but third-party users would post comments in response to those links that arguably were defamatory. And it was held that they were liable for that, even when they weren't actually on notice of those comments. So the High Court did say that if there was going to be a change in defamation law because of the breadth of responsibility for publication, then it would need to be done by the legislature as opposed to the courts. So this process was already underway. There had already been some consultation about it. And the government has just released its recommendations and as well as a draft of the amending bill.
So what's your take on the draft then? Are these proposals heading in the right direction, or are they perhaps missing things that might be really necessary moving forward? Yeah, what's your take?
I think I've got a bit of a mixed view. I think they're definitely heading in the right direction. The issue, of course, is that they're confined to defamation law. So they don't actually deal with liability for other types of publication that may be problematic. So, but that's what the scope of the government's remit was for this, and it may be a first step in the path to, and then there may be consideration of other types of law down the track. But I do think that what they have recommended in the defamation space is sensible. There's a few recommendations, and one of them touches on this search engine liability. Another touches on this like broader intermediary liability, where they're not the intermediary is not the author or originator or poster of the content. So there's two options actually introduced in that regard. I might start with that because that's a quite major one. So that's the intention of this reform, is to deal with the Voller situation. And it's where an intermediary didn't didn't create the content, didn't author it, didn't post it, they're not the originator, but they do provide some sort of online service that facilitated the publication of that post. So there's been two separate models put forward for further submission by interested stakeholders. And the first of those is a safe harbour defence, which would turn on notice, and then there would be, and basically it's shifting the dispute to being between the originator and the complainant. And so the intermediary acts as an intermediary and kind of connects the two. So what would happen is the complainant would need to send a complaints notice, and that it's specified what that complaints notice needs to include. And then the intermediary would need to pass that on to the originator, and the originator could decide whether to consent to provide their contact details to the complainant. So the complainant can then issue proceedings against them, or issue a concerns notice, and then eventually, if need be, commence proceedings against them.
Yeah.
If the originator is identifiable on the face of the post, then this defence wouldn't be triggered at all. So essentially, that the intermediary would have the benefit of this safe harbour defence from the start, because the policy rationale here is that really the originator and the complainant should have to fight it out between themselves.
Yeah.
So it really is triggered where the originator isn't identifiable. So that's model A, which it's an interesting one, but there's issues there around would the originator ever provide their consent to be unmasked?
Yeah, absolutely. So taking all of this into account, and then also perhaps, against, in the context of what's happening in other jurisdictions, might these proposed reforms, bring us up to speed, with our other jurisdictions in ensuring that our laws are fit for purpose, or are we still going to need to implement further reform down the track?
Well, this kind of safe harbour model is similar to what is in place in the UK under Section 5 of the Defamation Act over there. They do have this kind of notice and takedown regime. It's much more complicated than the one over here, and I think the Defamation Working Party here has really worked to simplify the process as much as possible. So I think that it would be, following that, the course that has already been forged overseas, but whether it actually is the right course is still a matter of debate, because of course there is this model B that's being proposed as well, which is more focused on beefing up the innocent dissemination defence that we currently have under Section 32 of the Defamation Act. It would be introducing another form of innocent dissemination, which is focused on digital intermediaries. And it would essentially mean that once a digital intermediary is on notice of alleged defamatory content, they have a choice to either take it down within 14 days, or they can defend it on another basis. So on the basis of truth or honest opinion or public interest, or one of the other defences under the Defamation Act. So in a way, it's not wildly different from what we've got already, but it does provide a bit more certainty than the current defence, because the current defence doesn't specify that it is available to digital intermediaries, even though it has been applied to digital intermediaries. It provides a longer period for the intermediary to assess the claim, the complaint, and to take action. And it also provides more detail as to what has to be included in a complaints notice. So in order for that notice to be triggered properly, in order to be effective.
Well, there's certainly a lot coming down the pipeline. And this is a really helpful explainer for our listeners as to what the reforms are and what it could mean for the law here in Australia. We're going to have to keep in touch with you, Marlia, if and when these reforms do pass, and how that's going to impact the day-to-day experience of practitioners in this space. Marlia Saunders, thank you so much for your time.
Thanks for having me, Jerome.